Welcome, everybody. Thank you so much for being here. My name is Marcia Eli, and I am delighted to greet you on behalf of the Brooklyn Public Library, our Arts and Culture team, BPL Presents, and BPL's newly opened Center for Brooklyn History. Tonight's conversation pulls back the curtain on the unsettling ramifications of the Supreme Court's conservative majority. Supermajority, I should say, and it's inspired by a book appropriately titled The Supermajority, written by Michael Waldman, who I'm thrilled is here tonight, along with another expert on our democracy, Jesse Wegman. With the court's current term beginning exactly 2 Mondays ago, this conversation could not be more timely. Tonight we'll bring historical context to these last 2 years and unpack the major decisions that have left many of us reeling and look at the possible next wave to come. Before I introduce Michael and Jesse more formally, I want to share that towards the end of the program, you all will have a chance to ask your questions of them. And I also want to make sure that you know that copies of Michael's book as well as Jesse's are both available at the CBH store. And I hope you linger and have your book signed and chat following the program. Now, it is my honor to tell you a bit more about Michael and Jesse, and I'm going to keep it really brief because I could really go on at length about the expertise and perspectives that they both bring, but let's hear them instead of hearing me talk about them. Michael Waldman is the president and CEO of the Brennan Center for Justice at NYU School of Law. His recent book, The Supermajority: How the Supreme Court Divided America, is an incisive analysis of how the Supreme Court's conservative supermajority is overturning decades of law and leading the country in a dangerous political direction. He's also the author of 7 other books, including The Fight to Vote, A History of the Struggle to Win Voting Rights for All Citizens, and The Second Amendment, a biography. Jesse Wegman is a member of the New York Times' editorial board and also a leading expert on our democratic institutions. Wegman regularly pens opinions about the Supreme Court and national legal affairs, including as recently as this past weekend, which saw his latest opinion published in the New York Times. He is the author of Let the People Pick the President, The Case for Abolishing the Electoral College, and is currently completing a biography of James Wilson, the most democratic of the founding fathers. So please help me welcome Michael and Jesse to the stage, and thank you both for being here.
Hi. Thank you, Marcia, for that introduction. So I'm going to just begin. I'm going to say this is an absolutely superb book. I would have read it even if we weren't doing this event, but I read it much faster because we were. It is on its face, it is about this court today in 2023, and it's about 3, earth-shattering rulings that came very close together last summer, the summer of 2022. But it is really about so much more than that, as you'll find when you read the book. And I strongly recommend that you do. It is one of the best and most concise single primers on the history of the court and the history of the court's role in America that I've ever read. And I think I think you can't go wrong in picking it up right now and reading it. So maybe some of you already have. I want to start with something tonight that I learned in reading it. I'd like to see a show of hands. Does anyone here know? And please don't answer if you've read the book and you got the answer that way. In what year was the Chief Justice of the United States last named by a Democratic president? Anyone know the answer? No hands. 1946. One more question. In what year did the court last have a majority of justices appointed by a Democrat? Anyone? 1970. These are remarkable numbers. The latter is before I was born. The former is almost before my father was born. One way to look at this is through the lens of partisan fairness. You all know these statistics. Democrats have won 7 of the last 8 popular votes, and yet Republicans have named 6 of 9 justices, a supermajority, to use tonight's preferred word, in perhaps the most counter-majoritarian institution in American politics. But another way to look at it, and I think most pertinent to tonight's discussion, is that the court has a very long tail. Majorities are formed over years. They take decades to issue their opinions, and then those opinions can live for decades before being challenged. All of this happens outside the reach of normal electoral politics. Even as these justices are making decisions that impact the most sensitive and contested parts of American life, we can't vote them out. Now, saying that the court as an institution develops slowly isn't the same thing as saying a particular court moves slowly, and that's why we are here tonight. A court assembled through the most hardball politics any of us have seen in our lifetimes, a process rife with cynicism and hypocrisy, a court that has upended decades of established precedent in the blink of an eye with little regard for the wisdom of prior courts and none at all for the usual criteria by which courts decide to change their course. A court whose supermajority behaves with impunity, mocking the idea that as the highest court in the land, it should be bound by the highest ethical standards in the land. Under these circumstances, the court should be all the more cautious in how it rules and how it conceives of its role in American government and society. Yet this court has gone in the exact opposite direction, moving faster and more boldly than almost any before it, often in ways that are completely out of step with the American public. And yet, we still abide by the court's rulings. We, or most of us, feel an instinctive protectiveness of the court as an institution that at least has the capacity to sit above politics. In the oral arguments last year in the Dobbs case, Justice Sotomayor asked, if people actually believe that it's all political, how will we survive? How will the court survive? That is a great question, and this great book, The Supermajority, helps us to work through it. How to respond to what millions of Americans increasingly consider a lawless court while not destroying it in the process. So, Michael, I want to talk to you about that, but first, can you just explain briefly, to set the stage for the discussion, the 3 cases that you chose to center this book around from last term and why you placed them at the center of your narrative?
Absolutely. And first of all, if I might start by thanking Marcia Ely and the Brooklyn Public Library and Brooklyn Historical Society for bringing us together. This is, I say, as a Brooklynite, an extraordinary institution, and we're really fortunate to be able to be part of it. And thank you, Jesse, also to you, both for your kind words and the incredible education you provide to all of us in your writing, in the Times, in your books, and in every other way. The book on the Electoral College was extraordinary, and I can't wait for James Wilson. So the 3 cases that are described, they came at the very end of the first full year of this supermajority of very conservative Supreme Court justices marching more or less in lockstep. And they were the last 3 days of the term. And you are familiar with at least one of them. So there was the Dobbs case, which overturned Roe v. Wade and Casey, and thus overturned the federal constitutionally protected right to reproductive rights that American women had seen in the Constitution for half a century, but also did so in a way that put at risk all the other privacy rights that had been interpreted in the Constitution. The day before that was a case called Bruin, and that was by far the most sweeping and I would say most extreme Second Amendment case in American history. That was a case that said, building on the D.C. versus Heller case, which the first time the Supreme Court ever ruled that the Second Amendment reflected an individual right to gun ownership, was just in 2008. And that was written by Justice Scalia. And I thought it had the history wrong, but it also made clear you could have strong gun laws. Justice Scalia was asked once, what's the difference between you and Justice Thomas? And he said, well, I am an originalist, but I am not a nut. Justice Thomas wrote the Bruin case. And it says, in effect, you cannot consider contemporary, current public safety concerns when deciding if a law is constitutional under the Second Amendment. Only history and tradition, only in effect what the laws were in the late 1700s. The third case, which got a lot less attention, which was not an incendiary social issue like abortion or guns, was a case called West Virginia versus EPA. And this case marked the beginning of something that we're already seeing build momentum, which was an assault on government's ability to act to protect the public and the environment and public safety, the administrative state, regulatory agencies, and that sort of thing. These three cases in 3 days, they crammed decades of conservative social policy into those 3 days. And when you think about the topics, going back to the political point you were making, and then think about the affirmative action case a year later, guns, abortion, the interests of the fossil fuel industry, that doesn't sound like a court. That sounds like an RNC caucus. Highly political opinions moving the country, the Constitution, and the court way to the right.
That's great. Thank you. I want to get into the politics of the court, but before we do, and actually this somewhat implicates that question, is something you just hinted at in that very helpful summary, which is originalism, and the way that the court has wielded this idea, which is only a few decades old, ironically, but I would love you to talk a little bit about specifically Bruen and Dobbs, the gun case and the abortion case, and I'm so glad that you put them together in the book because it really helps us to see just how unmoored this principle is when it's applied to actual real-life cases.
You're exactly right that this idea of originalism is really relatively new. It was not the way the Supreme Court ever made its decisions up until really 2 years ago in any significant way. The idea of originalism is that the only legitimate way to read the Constitution is to ask what it meant to the people who ratified it at the time, which mostly means in the late 1700s. In some instances, it may refer to, for example, the 14th Amendment, which was in 1868. This has an extraordinary number of problems. First of all, it relies on the assumption that we can know what history was, what the right history was, what the precisely accurate history was. And we spend all our time arguing about history. It's the argument without end. Think of all the events at this hall and in other places. So much of the historical factual record that they rely on is just made up and is just wrong, or we can't know. You're familiar with this in writing about the Constitutional Convention. Remember that the framers argued with each other and changed their mind, and half the stuff they said was spin. We all read about James Madison, and we all read the Federalist Papers, and I am sure you quote the Federalist Papers at least once a month in an editorial in the Times. We all do. The Federalist Papers were a series of op-eds written by Madison and Hamilton and John Jay to argue with another series of op-eds that were against the Constitution being ratified. They were anonymous. And in Federalist number 10, Madison anonymously wrote, he said, well, the purpose of the Constitution is we don't like faction. The purpose of the whole thing is to not have factions, political parties. And we all quote Federalist number 10. Well, a year and a half later, what did James Madison do? He organized a political party, the one we now call the Democrats. So then he started writing a different series of op-eds under a different pseudonym saying, some people say that factions are bad. They obviously don't know anything about how the world really works. Yet we're supposed to think that we can decide today what the country should look like based on that. But even if you get the history right, it is a frankly reactionary, frankly backward-looking, ultimately absurd way to run a modern, growing, forward-looking country. In the Bruen case, again, it presupposes that you can look at what they did back then and decide what the gun rules today ought to be. And this devolved into parody when the lower federal courts tried to implement it. Upstate New York, New York State, the law that was struck down was the law from 1911, which to me is kind of history and tradition. But anyway, 1911, banning the carrying of handguns, more or less, in New York, because this is a rather crowded place. And it was struck down by the court, and so they passed a new law in the state legislature, and the federal courts had to look at it. In Western New York, a trial judge said, well, history and tradition. For it to be history, 2 examples from the colonial era, that's a mere trend. For it to be tradition, you need 3, and I can find no example of a tradition of laws banning guns at sleepaway summer camps in the late 1700s, therefore it's unconstitutional, let alone subways. He got so mocked for this, he kind of pulled back. But in Texas, we saw a case that took this logic to its most outrageous extreme. It's called the Rahimi case, and it's actually going to be heard by the Supreme Court this year. They said they looked at a law, a long-standing law, taking away guns from people with adjudicated records of domestic violence. And the court, a federal court of appeals, in effect said, well, back then, that wasn't a problem, or it wasn't seen as a problem, so that's unconstitutional. It's a genuinely reactionary approach. What were the social values of property-owning white men from the 1700s? That's how we should govern ourselves today. And there is no history and tradition of using just history and tradition to make the rulings. We saw this as well, of course, in the Dobbs case. When the opinion leaked, one of the things that caught people's attention the most was the fact that it relied 6 times on somebody named Matthew Hale, who was an English judge from the 1600s, I think, who sentenced women to death for witchcraft, and who created the doctrine of marital rape, that a husband cannot be accused of raping his wife because she hath doth consented or whatever. And they cite him 6 times as this is how we should govern ourselves now. It's just a frankly absurd way of doing things. And think about it. In Great Britain, when somebody proposes a new law, they don't say, oh, that's a really interesting idea. The key question for us to ask is, what did King George III think about that? Because that's really how we're going to govern ourselves now. But that is genuinely taken to its extreme what this approach suggests.
Can I ask, I think along with most other people who are aware of originalism as a concept, think of it as a relatively modern invention, largely by conservative legal scholars and judges. But you point out in the book in a really helpful way that there's actually an earlier example of originalism that is in some ways as harmful, probably more so than anything we're seeing today. And I was interested if you would explain what that example is and then talk about how maybe this echoes down through the years to today.
So there really have only been 4 major, really big cases decided by the Supreme Court using an originalist approach. These 2 cases, Dobbs and Bruin, the Heller case that I mentioned, and Dred Scott. So Dred Scott, as you know, was from 1857. And what was interesting about it is that the founding generation had died off not that long before. So Roger Taney, the Chief Justice who wrote that opinion, said, I'm going to go back and look at what the original intent was. And it was relevant not only because it was a frank and explicit use of what we would call originalism, but because the dynamic of the response to that case also is part of the pattern of how the Supreme Court has come to be the way it is. The Supreme Court, generally speaking, throughout the country's history, the only reason it has the power it has is because we give it that power. The part of the Constitution that deals with the courts is only 1/10 the length of the part dealing with Congress and the presidency. And most of the time, the Supreme Court, for better or worse, kind of follows the consensus of the country or the elite of the country. It hugs the middle. But the first time it really went off the rails was Dred Scott. It was only the second time the Supreme Court struck down or found unconstitutional a law passed by Congress. And in Dred Scott, they said, well, it is unconstitutional, based on the founders, for Congress to bar slavery from the territories. In other words, it's national. It's not limited to the South. And worse than that, that black people are so inferior they cannot ever be citizens. And one of the ways this has resonance now is this spurious use of originalism. The other is the reaction. This case was extraordinarily controversial. It led to the rise of the Republican Party. It led to Abraham Lincoln's election to the presidency. In a sense, it led to the Civil War and the end of slavery. It was one of the few examples where you had extremism and overreach and then a backlash. And it was not a backlash limited to lawyers or judges, but to the people, to voters, to people demonstrating and organizing. It's also worth mentioning, just looking for historical resonance, it was the first major Supreme Court opinion to leak. It didn't leak to Politico. It leaked to the incoming president-elect, James Buchanan, who wanted them to rule this way. He thought they would solve the problem of slavery for him, or the problem of opposition to slavery, more accurately. So he lobbied them. They leaked it to him, and he got up and gave his inaugural address and said, well, we all know the Supreme Court is going to issue a big ruling on slavery. None of us know what it's going to say. Let's all agree that whatever it says, we'll abide by it, right? And when he said that, that actually began the firestorm because people knew what that meant.
I want to move on from originalism in a moment because there's so much to cover here. The book is so full of great ideas and so much to think about and talk about. But I just want one more point, which is just that reading those two cases side by side as you tell their stories, it really is shocking how even by its own terms, originalism is basically just a shell game, right? Like these people aren't historians. You know, one of the things you learn when you go to law school and you practice law, and probably a number of people here do, is that Supreme Court justices are not necessarily smarter than the rest of us. In some cases, they're maybe not as smart as the rest of us. They do one thing extremely well, and then they're not that bright when it comes to some other topics, such as history. And so when you look at the way they handle history and mishandle history in Heller, but also in Bruin and Dobbs, it's shocking how history is staring them in the, if they want to rely on history and tradition, it's staring them in the face that they're coming to the wrong conclusion, and yet they still get where they want to go.
In Heller, they said, in the courtroom, they said, well, the reason people had the Second Amendment was so they could fight off grizzly bears in the colonies of the East Coast, which don't have grizzly bears. In the Bruin case, history shows that there were many, many, many rules against carrying weapons because they were deemed dangerous and scary. One of my very favorite historical counter examples is that in 1824, the University of Virginia was created, and the new board of governors of the University of Virginia voted on the rules governing the university. It had everything like graduate students can teach large lectures and things like that, and said, and there will be no guns on campus or swords, presumably because they were dangerous. And the people the 7 members of this governing board who voted for it included James Madison and Thomas Jefferson. So they didn't think that was violating the sacred right to bear arms. The Dobbs case, the issue on the history on abortion, there in fact was no laws prohibiting abortion at the beginning of the country's history. It actually came in the mid-1800s when, among many other things, the profession of medical doctors, men, wanted to supplant the profession of midwives, women, and so they passed a bunch of laws governing things like abortion. And they just get, to the extent that they are relying on the history, they rely on it in a most tendentious and inaccurate way, and it's called law office history. It's basically they rely on the lawyers to bring them cherry-picked facts, kind of like the way movie posters take the review, like one word out of a review. That's what a lot of the history is.
The ellipsis matters greatly, as we see with the NRA and the Second Amendment. Let me ask you this. I want to pull back the lens a little bit and talk more broadly about the court's role in society. You mentioned Lincoln, and Lincoln says in his first inaugural address his famous line from this is, "The people cease to be their own rulers if the court had, that's the quote, the idea is that if the court actually has the final say over the meaning of the Constitution, the people cease to be their own rulers. And I would love you to just talk a little bit about that idea, and also, why did we give the court this power? Why did the court claim this power and we acquiesced 220 some years ago? How did that develop, and why today do so many Americans seem to accept that the court plays this role?
You know, and that power, it's not that this was a sneak attack, in the sense that in many ways that power was implicit in the structure of the Constitution as it came out of the Constitutional Convention. They knew there was such a thing as judicial review, especially in the states, but they didn't envision it evolving in the way that it has. We give the court this power because there's been a structural benefit in having an independent judiciary to uphold the Constitution, at times to be what they call counter-majoritarian. In other words, not just following kind of what the mob wants, what the people want, even what the elected officials want. But for most of the time, the idea was that it was not above the rest of government, but a co-equal branch. Even, for example, the Warren Court, which was seen as activist, almost never struck down a law passed by Congress, because that would be seen as too activist. I mentioned the Dred Scott period. I think there are two other major eras where the court went much further than other times. One was at the beginning of the 20th century, in what the lawyers call the Lochner era. And it was a similar time to today, in that you had massive economic change and dislocation, demographic change. You had the retrenchment on civil rights and voting rights in the South, but in sense that government was corrupt. And the Supreme Court of that time, the elitos of that court, thought their job was to make sure government couldn't do anything about it, could not protect workers, could not protect public safety. And they issued a series of rulings using the Constitution, their argument about the Constitution, to say that it prohibited government from regulating, from acting. And again, this was hugely controversial. I didn't realize until researching the book that the sort of legendary 1912 presidential election, which had Teddy Roosevelt running as the Bull Moose progressive, and he was challenging his hand-picked successor, Taft, and Woodrow Wilson was the Democrat and Debs was the socialist. They don't have elections like that anymore. Teddy Roosevelt, one of his biggest issues was taking on the Supreme Court on exactly these grounds, on Lochner and other cases. And he had some kind of out there, rather ill-thought-through ideas of what to do about it. But this was a major public issue all the way up to the 1930s and his cousin Franklin's administration, when he had his great fight with the court, leading to his attempt to expand the court, and he lost, but then the court backed down. The third era was, in a sense, the time that matters for us most in our own minds and imagination and muscle memory. The only time the Supreme Court ever was ahead of the country in terms of protecting rights and advancing equality was the Warren Court and its aftermath. That was the only time it was more liberal in the country. And it started with absolutely vital decisions, in my view, like Brown versus Board of Education. Also cases like the one-person, one-vote case, which stopped the flagrantly unequal representation in legislatures and Congress between urban and rural areas. But over time, and when you look at the kind of volume of things they were doing, I certainly agree with the substance of the rulings, but they were coming hot and heavy, and they created their own backlash. That created a backlash too. And we're living in that backlash. And it's particularly significant because it wasn't until 1958, in a case called Cooper v. Aaron, that the Supreme Court ever said, and it was unanimous, we are the ones who decide what the Constitution is. Nobody else. Everybody has to follow us. And now, at one level, thank God they did. That was the Little Rock school desegregation. But at the very moment they assumed that imperial power, they also lost their. They began a journey to the right that wound up giving them more power with less accountability than at any other time.
You mentioned Brown v. Board of Education, obviously a case I think that's generally broadly considered the greatest in the court's history. It was, I had forgotten this detail about it, but that Earl Warren, the Chief Justice, wrote it intentionally very short. And he wrote it very short in order that it be published in newspapers all over the country and read by regular Americans, not just by lawyers, not just by law professors and other judges, but by regular people so they could understand the court's reasoning and the values embedded in that reasoning. I think that's just a fascinating and wonderful idea, and I think when I look at the court's rulings today, and as someone who has to write on deadline about 150-page or 200-page opinions, it's very easy to get lost in the legal legal argle-bargle, as Justice Scalia once called it, or the nuances and the jargon and the minutia. What do you think about that sort of development, almost the professionalization of the court as a bunch of lawyers and scholars? How does that affect how we, the people, can interact with our own Constitution?
It's such a great question, and you're right that it was about 10 pages long. And of course, part of what was significant there is Earl Warren had been the governor of California. And the Supreme Court of that era, and other eras too, times when the court saw their role in a more circumscribed way very often. The justices were former governors, attorneys general, United States senators, a former president of the United States himself, Taft. These were the kinds of people who were on the Supreme Court. Now, 8 of the 9 are former federal appeals court judges. All but one went to either Harvard or Yale Law School. They're technically proficient. They've been vetted to the eyeballs, especially by the Federalist Society on the right, and we'll, I'm sure, talk about that, but to make sure there's no wandering and no evolution that nobody's waiting for. And what they write are longer and more dense and more mystified. It's done in a way that assumes that they're reading the runes of history. They're wearing robes and acting like wizards as opposed to like government officials. And it is part of the mythologizing that the court endlessly does about itself so that we take it seriously the way they want to be taken seriously. I think it's a mistake. Now, I should just mention, as you know, I worked for Bill Clinton. And I was his chief speechwriter, and he was eager to break this pattern. He wanted to appoint someone who wasn't a judge, who was a politician, to the court, and he kept
Bill
trying.
Richardson?
Not Bill Richardson, no. That would have been interesting. But no, he really wanted Mario Cuomo. He asked him twice.
Cuomo, of course, was first.
He asked him twice, and he couldn't decide. He was the Hamlet on the Hudson, so eventually he moved on. He tried to get George Mitchell, who had been a federal judge, who was the U.S. Senate Majority Leader. He would have been tremendous. He said no. He tried to get Bruce Babbitt, who was the Interior Secretary, had been the governor of Arizona. And this is when people say, did the Democrats take the court seriously enough? The environmental groups fought with the Western senators over who would be the replacement Interior Secretary, so they didn't nominate Bruce Babbitt. So, that's how history turns.
You talk about, you mentioned just now the Federalist Society. We have to talk about this, and then Leonard Leo, in any conversation about the current court. And I think just to set it up, what I think is remarkable about this, obviously, I think most people here are probably aware of the Federalist Society's multi-decade project to the backlash that Michael was just talking about to the Warren Court, which has led to the overwhelmingly conservative federal judiciary we now have and this supermajority on the Supreme Court. But what I think is remarkable about this project is just how open they've been about it the whole time. This is not secret. Well, where some of the money comes from is secret, but the project itself is not secret. And I'm just going to flag a few short quotes. One of them is from Mitch McConnell himself, of course, who, after preventing Barack Obama from putting a third justice on the court for an entire year, said in a speech in 2017 that it was his proudest moment as a senator. Literally stopping the president from doing his constitutionally mandated job, not even pretending to take the Senate's role in that seriously. And then the other is a quote that Michael includes in the book from Don McGahn, who ended up being Donald Trump's chief of staff?
Counsel.
Right. Right. Did it matter?
Well, he was a cooperating witness with Mueller the whole time.
And Don McGahn, in 2018 at the CPAC, the Conservative Public Action Conference meeting, he says, and this is in regard to the third case Michael talked about, the environmental regulation case, he says, there is a coherent plan here where actually the judicial selection and the deregulatory effort are really the flip side of the same coin. In other words, you're appointing people specifically to decide certain cases in certain ways, and that's the whole game. And it's very hard not to understand that as just raw politics rather than whatever we might consider rule of law. So can you talk a little bit about the way the Federalist Society has transformed the judiciary and thus transformed American society?
I did not know that quote. That's really quite
Is that not from your book?
I don't think so.
Oh. Well,
it could be ChatGPT hallucinating.
Maybe. Whoops.
It could have. He could have said it, even if he thought it. You're exactly right. This is a country with a huge penchant for conspiracy theories. The anti-Mason Party, QAnon. This happened. This is in plain sight. The Federalist Society started as a student club for law students who felt marooned, conservative law students who felt marooned at liberal law schools. And over time, it grew into something we've never had before, which is a fully functioning political machine to capture the federal judiciary. It has been captured by a faction of a faction. They picked the judges. Donald Trump very proudly said, I will only pick for the Supreme Court people chosen by the Federalist Society in advance, and he published a list while he was running. It was part of his way of trying to make peace with the conservatives in his party who were not wild about him. They do this as well for the lower courts, where there are a lot of people we don't even know about until they make some outlandish ruling that tries to change the country from a single courtroom. They back these nominations to the hilt with massive amounts of money, spending tens of millions of dollars through affiliated organizations on ads, supporting the nominations or praising, for example, McConnell for blocking Merrick Garland. They back groups to bring the cases and to write the friend of the court briefs, which are so important in Supreme Court litigation. These are sort of the Greek chorus of outside briefs that often are really important in educating the court as to the issues. And I used to look at this, I run the Brennan Center for Justice, as Marcia mentioned, and, I was impressed by this effectiveness of the Federalist Society. And I used to look and say, wow, they really don't have that much money. Well, turns out, a couple of years ago, somebody gave Leonard Leo $1.6 billion to spend on this operation. So this is, again, a machine, a very well-oiled and well-funded machine. And again, it's the part of government that is the most impervious to accountability. So that makes this kind of thing all the more dangerous.
And can we talk about, in that vein, I think people are very familiar with the idea of money in politics, right? And Citizens United and the kinds of issues that are raised by that, First Amendment issues and other political corruption and issues. But I would like you to talk a little bit about money in religion, because you write about this in the book, and I think religion is obviously one of the central animating projects of this particular supermajority, right? They're a very specific religion, right? A certain brand of Christianity that they have sort of elevated above most other civic concerns and also other religions. And you mention in the book the ways in which a lot of these donor networks have contributed to the growth of those cases and the pushing through of those cases up to the court, which we're continuing to see today.
Well, it's really interesting. This is both a political story and a doctrinal story. The political story is that after Roe v. Wade in 1973, it was not that controversial a decision. And interestingly, it was really not very controversial among Protestants and evangelicals. Hard to imagine given the way politics have played out. It was seen as a, quote, Catholic issue. But within a few years, that changed. It became a cause célèbre for the turn to the right among American Protestant groups and denominations, and the way that became a significant part of the Reagan coalition and the New Right, so that by the time Reagan ran for president in 1980, he, who had signed a law legalizing abortion in California, was crusading to overturn Roe v. Wade. But they really didn't get very far. They wanted a constitutional amendment, and they had other things like that weren't succeeding, and they changed their view and realized that they needed to focus, as they saw it, on the courts and who was sitting on the courts. And over time, that became a central mobilizing, motivating force for the religious right. But part of what they needed to do was change the politics and how politics happened. So the case Citizens United that Jesse mentioned, which we're all familiar with, a little bit at least, it was in 2010. And that said, that effectively almost completely deregulated big money in American politics. It followed on an earlier Supreme Court ruling called Buckley versus Vallejo, which said, in effect, that money is speech. And this said that if it was an independent, if you could claim spending was independent, basically corporations and unions could do it, and then very quickly, it just deregulated everything. Citizens United was argued by a guy named James Bopp. He was the general counsel of the National Right to Life Committee. There was a fusion of these movements. They saw this as part of the coalition. When you think about the conservative coalition as being partly social conservatives, partly business-oriented deregulators, and also, at least for a time, anti-Russian hawks. I guess that part might have changed. Their legal strategy reflected that. You saw this in these cases in the last couple of years, where now, because the court has embraced the First Amendment, and especially the religious parts of the First Amendment, as the way to enhance and advance conservative social policy, you see the First Amendment being used to poke holes in otherwise universal laws, otherwise universal human rights laws, otherwise universal public safety and public health laws. And that was a number of the cases that they did here. You know, some of them you can see the arguments for it, but it's basically, if you can call something a First Amendment religion issue, you're far more likely to get these justices to go along with you.
James Bopp, this is the same James Bopp who, after the Dobbs ruling last year came out, and there were stories all over the country of women being denied even life-saving care in some cases surrounding their pregnancies. There was this story that you may remember of the 10-year-old girl who was raped and had to go across state lines, I think from Indiana, to get an abortion. And James Bopp first denied that it was a true story, right, as many in the sort of right-wing media ecosystem did. They said it couldn't possibly be true, and then when it turned out, they picked up a guy and he admitted to the crime. James Bopp said he hoped that the girl would understand both the necessity and the benefit of bringing the child to term. So this is some pretty extreme, these are extremists, and they are now in control of one of the three major branches of our government, of the three branches of our federal government. And I want to come back to the point you briefly touched on earlier, which is the relationship between the court and public opinion. Because I think that's a really important and nuanced thing for people to understand. I think there's a very common misapprehension that, the court isn't supposed to consider public opinion at all, right? And they do that, they're just another political branch. But in fact, as you said, the history of the court tells a much different story. And I just wanted to flag this wonderful quote from Justice Kagan in a speech she gave last year. She says, you run the quote at length, and I'll just read the beginning of it, but I highly recommend reading the entire thing. It's a really powerful passage. But she says, if over time the court loses all connection with the public and with public sentiment, that's a dangerous thing for democracy. And I'll just say a little bit more of it. The way the court retains its legitimacy and fosters public confidence is by acting like a court, by doing the kinds of things that do not seem to people political or partisan, by not behaving as though we are just people with individual political or policy or social preferences that we are making everybody live with, but that instead we are acting like a court, doing something that is recognizably law-like. Can you talk about Justice Kagan's characterization of the role of the court and how it relates to public and responds to public opinion?
It is a very powerful talk she gave. It was to other judges after the term ended, and she was clearly very upset. She's a very gregarious, funny person. There were not a lot of quips in this talk. The point she's making is that while we know to a certain degree it is a bit of a noble fiction, we have to treat the court as if it's a court, or else its rulings have no legitimacy. What makes it legitimate? Well, following precedent, for example. The idea that even if you don't like an outcome, if you're a judge, you're going to follow what came before unless there's some fairly specific bases on overturning things. And I should note that Clarence Thomas, when asked about stare decisis, which is the Latin term meaning precedent, and he said, well, stare decisis, that's for people who don't want to think. They mock the idea. Also, that they need to have what's called a case in controversy, which is language from the Constitution, I believe, meaning it has to be a real case. It has to be one person suing another person. And what we've seen in the last few years, increasingly, flagrantly, are made-up cases where there really aren't people who were injured the way they say they were. They were just basically concocting a case to get it in front of these justices to make an op-ed-like ruling. Whether or not people have relied on a ruling for years and years, as was certainly the case, for example, with Roe v. Wade and Casey, all of these things are what makes it a court. And if you don't have that, then it looks just increasingly political and indeed even partisan. And so the justices, they've now taken to going out and giving these speaking tours to try to justify themselves before they make another big lunge at the Constitution. One of my favorites, which I refer to, is Justice Amy Coney Barrett spoke in Louisville, Kentucky, saying, people think we're just politicians in robes. That's terrible. We're not. We're really not that way. And she was speaking at the Mitch McConnell Institute at the University of Louisville with him sitting there smiling, possessively. You don't want the court to only look at public opinion, but you do certainly want any powerful institution to be aware of it and to understand the impact of their rulings. And they profess loudly, oh, we don't care, we don't care. And you know that they're duff protesting a little too much. They must be aware, they are aware, that public trust in the court, by all measure in public opinion polls, has dropped to the lowest level ever recorded. And one of the great questions for us is, are they so ideologically committed? Are they so enmeshed in this political machine that they will not adjust their course in the face of that, or will they see this as a reason to pull back in some significant ways?
Well, and another element of that loss of public support, which is critical to the court's legitimacy, of course, is the issue of ethics at the court. And I think I'd like to just have you touch on that before we move to the only potentially optimistic part of this talk, which is reform. Obviously the court is having some major ethical issues right now. Justices Thomas and Alito, I think, are leading the pack in that regard. But even, as you pointed out, you used this example of Justice Gorsuch, who literally on the same day that the court agreed to hear a case in which it was going to ultimately hobble labor unions, he gave a speech at a foundation that was funded by the same people who had funded the lawsuit against the unions. So it's very hard to watch that and to read about the stories around Clarence Thomas and Samuel Alito and think that these guys in any way care about how the public perceives their integrity and their neutrality or their professed neutrality. And I wonder, can you tie that issue, the ethics issue, into the broader, the impunity that they seem to feel there, into the broader question of the supermajority and how it was assembled in the first place?
Well, it's the impunity. It's also the corruption of their judgment that it reflects, in the sense that so many of the things they're doing are really problematic on their face, and they don't seem to really see it quite so much. So as Jesse mentioned, and as you may know, in the last year especially, it's become clear that the court has an ethics or even a corruption problem. They're the only court in the country that does not have to follow a binding code of ethics. Some of the controversies that have brought this to light, a lot of them were published by ProPublica, the tremendous online journalism site, nonprofit journalism site. Clarence Thomas in particular, I think we have not yet fully seen all the stories. It's not just that this guy Harlan Crow, who is a really extreme right-wing billionaire from Texas, it's not just that it turns out, provided lots and lots of free luxury trips and lodging and everything like that. And by the way, it's worth mentioning, Thomas disclosed this all, his largesse from Harlan Crow, who had not been anybody he knew until he became a Supreme Court justice. He disclosed this until 2002. Then the LA Times published a story on it, so he responded by not disclosing it anymore, but continuing to take the money. Harlan Crow didn't just provide the trips. He bought Clarence Thomas's mother's house and renovated it with her living in it. He paid for Thomas's surrogate son's education. If we looked at a state capital, if we looked at Albany or Springfield, Illinois, or anywhere, and we saw some state legislator and the rich guy in the town was buying the mother's house, we would say, oh, well, we know what that, look at the corruption there. You know, that's the oldest story in America. That's literally what was going on. And what was striking, especially around this, and also the other story involved Justice Alito, who was, it turns out, similarly taking very expensive vacations and trips and largesse from a different billionaire, Paul Singer. He said, well, he wrote a pre-buttal op-ed in the Wall Street Journal, and he needed an editor, honestly, and just, again, it's the arrogance that comes from the lifetime terms. He said, well, yeah, sure, I took this private jet up to go on the fishing trip, but there was an open seat, and it would have gone begging, so it really didn't cost anything. You know, he's in one paragraph he says, of course I can do this because this is a friend and it was just personal hospitality. And in the next paragraph, Alito says, but I can rule on all the billion-dollar cases involving him because I never heard of the guy. And so there's a common thread here which goes to the ideological project and how they got on the court. In the first ProPublica story, there's a marvelous painting of Justice Thomas and Harlan Crow smoking stogies at this luxury resort. And the painting is somewhat ludicrous. It looks like one of those paintings of the dogs playing poker, to be perfectly honest. But there's a third person in the painting with them, Leonard Leo, the head of the Federalist Society, who made, as I'm sure he didn't say, the shidduch to connect Clarence Thomas with his own friendly billionaire. And it's not necessarily that Thomas was a liberal and then he took the trip and then he turned into a conservative, but there's a corruption in the whole enterprise. It was a world of chummy money and ideological synchronicity. And there's a recent story about Justice Thomas going to the Bohemian Grove retreat, which is in Northern California. It's where a lot of men go and they walk around naked, and it's all these business executives and largely Republican politicians. And Thomas went, again, undisclosed to these things, and they interviewed one of the staff working there at this thing and said, well, what did the Koch brothers and what do they all talk about all the time? And the person said, I couldn't really remember. It was some oil company. It was called Chevron. Well, that is the major doctrine to undo regulation that the Supreme Court is about to rule on. I don't think they were talking about where the best gas station was in the town.
Well, and it's also this issue of corruption is, and as corruption laws themselves make very clear that it's not just about the corruption, it's about the appearance of corruption, right? And that's the important thing, especially with a court. You know, a court's entire legitimacy depends on the appearance of neutral arbiters. And so even if Clarence Thomas wasn't a liberal who would become a conservative after getting, some kickbacks from a billionaire developer, yeah, you feel like it doesn't smell right.
There's no way around it. People understand this more and more. It becomes a self-fulfilling downward spiral.
Right. I want to do, just as I promised, to just touch on reforms and then move to questions from the audience. You end your book by quoting the three words that open the Constitution: "We the people." And you use these words, and you say they are the most important words in the Constitution. And I think in this context, it's because any large-scale change to our system does have to come ultimately from us, from we the people. And I believe in that. I agree with that. And yet at the same time, as I read, the writer Matt Ford wrote recently, we the people have jobs and mortgages and families to worry about. So what do you do about that? You have people who spend all their lives interpreting the Constitution or misinterpreting the Constitution and state and federal laws and nothing else. And then you have the rest of us who very much would like things to be different in many cases, and yet have, jobs and mortgages and families to worry about. What do you do about that?
Well, and it can be exhausting to deal with this. One of the lessons to me from the history of this is that when there is overreach, as I said, there can be backlash, and that backlash can be significantly effective, although it can take a long time. The book talks about some of the ways we, the people, can respond to the court when it seizes power in this way and governs in such a misguided way. One way is voting. And just the general way the political system can respond. There has been already the beginnings, at the very least, of a very strong political backlash to this court. We saw it in the midterm election when, the party that controls the White House typically does poorly in a midterm. In this case, running on a reaction to Dobbs, but also fears for American democracy, the Democrats had the best midterm election for a party in control of the White House in decades. We've seen it in ballot initiatives all over the country where reproductive rights especially are being advanced, including in very conservative states. We saw it I think in a kind of very telling way in Wisconsin. So state Supreme Courts, as you know, most of them are elected. Whether that's a good thing or not is a different issue, but most of them are elected. Wisconsin is a very evenly divided state. Not the legislature because it's gerrymandered, but the public is evenly divided, and that includes when they vote for judicial elections. They went from an evenly divided state to an 11-point win for the Liberal candidate in April on the issue of the direction of the courts, including redistricting, including abortion. Now, it's worth noting that the Republican legislature responded by saying they were going to impeach her before she put her robe on.
The gerrymandered Wisconsin legislature.
But then, I don't know if you saw this, the Speaker of the Republican-led legislature in Wisconsin asked 3 conservative former state Supreme Court justices to give legal advice on how to do this. And somebody filed a Freedom of Information request, and the advice was, don't you dare do this. It's an outrageous attack on judicial independence, and they backed down this week. So we see it at the ballot box, first and foremost. So we don't have to 24/7 be talking about this, but when the elections happen, as conservatives, to their credit, have done, understand that the Constitution is something that can be affected by how we vote and who we vote for. There's also things Congress can do. Congress, for example, one of the most egregious rulings of the Supreme Court came before this supermajority. It was the 2013 Shelby County case, where the Supreme Court, led by John Roberts, who has a long career of trying to undermine these democracy laws, it gutted the Voting Rights Act of 1965, the most effective single civil rights law that the country had. Congress could restore the full strength of the Voting Rights Act tomorrow if it had the will. In fact, legislation to do that passed the House and actually had a majority of the Senate in the last Congress, but 2 senators, as not surprisingly, Sinema and Manchin, wouldn't change the rules to make it possible to pass. But no Democrat will run for the Senate now without saying, I will change the filibuster rules to fix the voting rights laws. There are even things like constitutional amendments. We have grown very uncreative and timid in thinking about changing the Constitution. You might say, oh, how is that possible? It's so hard to change the Constitution. And everybody always thinks that. And then things get bad enough, and you get a burst of new amendments about every 50 years or so, mostly to strengthen democracy. And we're at least chronologically long overdue. And there's a final thing that can be done, which, as I think you might know, the Brennan Center has really been focusing on and pioneering lately, which is state courts. There is an entirely different system of courts than the federal system that can be a bulwark for rights and freedom and protecting democratic equality. I'll give you an example. Every single state constitution but one has a stronger protection for voting rights than the U.S. Constitution does. But state courts have not interpreted it that way. So we have a broad project to try to encourage state courts to step up. We have Republican and Democratic former Chief Justices working with us. We have a publication called State Court Report. And finally, there are reforms that can be made to the Supreme Court itself. Congress can pass a code of ethics. No judge is so wise that they should be the judge in their own case. That's the basic premise of it. Congress could do it, but so could the Supreme Court. And I strongly believe in 18-year term limits for the Supreme Court. The basic idea is that nobody should have too much public power for too long. It's what George Washington taught us when he stepped down after 2 terms. Interestingly, it's really popular. It's really popular across the political spectrum, Republicans and independents and Democrats. It could be done by constitutional amendment, but it could also, I think, be done by statute. And I am not under any illusion that it's going to be a giant group hug were that to occur. The public is bipartisan on this. I don't think, likely that Congress will be. But this is an idea that is, there's a public consensus on it, hiding in plain sight, and I think it's an idea that will become increasingly important. So there's a lot of stuff we can do, but it's not going to happen overnight. But it can have a real impact.